Alright everyone, welcome back to Real Attorney Plays Ace Attorney, Episode 2, Part 2. Or possibly Episode 3, I'm not 100% sure yet. I think I'm going to stick with the numbering system that the game uses though, which I think puts us at, Episode 2, Day 2. So, let's just dive right in. As always, the information provided in this is for entertainment and educational purposes only. I am a real attorney, but I am not your attorney. I'm just going to go through this and see what comes up. Okay, so if we recall, this lady came under suspicion at the last hearing, at the first day of trial, which was yesterday. So she was arrested, but now I've agreed that unless I can prove that she did it or that her boyfriend did it, that means my client's guilty. So that was a stupid thing to agree to. Not something I could actually agree to, but we'll see how this goes. Oh, that was a quick turnaround. Scaring the security guard, yes, he looks so terrified over there. Who was with you? The murderer. Yes, it is a crime. That is, well, some states have specific wiretapping crime laws, but it's at the very least going to be some kind of invasion of privacy. Not to mention the trespassing that she likely had to commit to get there, or possibly burglary. Difference between trespassing and burglary. Trespassing is entering premises you're not allowed to be in. Burglary is, depending on exactly the state you're in, but basically it's entering either a dwelling or a structure with the intent to commit a felony or a theft inside. So depending on whether she had permission to be there at the time, and whether or not the wiretapping or the invasion of privacy amounts to a felony would kind of affect how that stuff goes, but it's going to be one of those things. So yeah, definitely a crime. Lawyer school. Why are you so angry? It couldn't possibly be that we got her arrested. That wouldn't make any sense. Okay, not gonna get a lot out of her here. Got the guard, got the camera. I'm not gonna waste time on that. I can't imagine there's anything important we're gonna find there. Okay, there's a plant. And he's probably right. There's probably nothing we don't know about, except apparently in this world the prosecution doesn't tell the defense anything about what they find. So I don't know what they found, but yeah, this place has been investigated, but we don't know what we don't know, so we gotta look. Oh, well. I'm guessing that's gonna come back later. Somebody probably stole some files or something. Alright. Wait. That's one way to look at it, a good marketing thing, like, come see the hotel where this crime of the century occurred. Yeah, I was kind of agreeing, especially his talk about the murder thing. He might. I'm wondering if he actually set the whole thing up to try to boost business. Although that'd be a weird thing for the bellboy to do. You would think that would be the like the owner of the hotel do something like that. Yes, you're so dangerous, dude. Not in a sexy way, at least. Murder Manor. Alright, so we found the screwdriver. I still can't get over there's something inappropriate looking about that picture, but I can't quite put my finger on what it is. Okay, if you're so concerned about the, like, scene remaining pristine, maybe you should, like, glue them down or something. Okay. Don't really have anything to present to him either. I guess we'll go to... examine. Oh, I bet this person is not at all the photograph of the killer. Okay. Yes, I'm sure it is a valuable clue for this crime. I can't just be taking crap from other people's offices. Like, now I'm committing theft. Okay, I understand this is just a game and court record is just a conceit they use. Me picking up a piece of evidence does not get it into the court record. I just want to make that clear. I'm going to pretend that instead of court record, that's just like my file. I can put whatever I want in my own file. Why can I only oh, because people won't notice one being missing, but if they were both missing, then someone might notice. Okay, everything's here is expensive, yes. I talked about that, how lawyers don't read most of their books. They're just for decoration. I thought it was a hunter. Was it him hunting? I wonder what happens if I pick the wrong thing. Okay, yeah. It was a picture of a hunter, I really thought. Alright, can I look not at the rest of the office? I really... Okay, guess not. Alright, let's see if you recognize the murderer. Yes, it's always great to get your witness statements in writing. Very helpful. I don't think you will be known as that. Okay, technically an affidavit means a sworn statement. I may or may not be a notary. If I'm a notary, then he can swear to it before me, but otherwise we'd have to go find either a notary or a court clerk or a judge or something and have him swear an oath that the statements in were true, and then it would be called an affidavit. An affidavit, you swear that the things you're saying are true to the best of your knowledge under penalty of perjury. Perjury is the crime of lying under oath, so it's basically considered more reliable because you are putting yourself under potential criminal liability if what you said in it isn't true. Okay, let's see if he has anything new to say. Okay, I guess not. Let's go back and see if Miss May has any new. Alright, let's present her with the affidavit and see what she has to say. Actually, I'm going to present her the photo first. Okay. She's gonna want this proof that it's him. In real life, she'll just say that the bellboy's lying. I'm gonna push her, see what she does. Okay, I'm taking this to the press. Yeah, I can't do that. You are not, as an attorney, allowed to make public statements that will impact or prejudice, prejudice the case. So I can't threaten a witness with publicizing stuff to get them to say something. I can't actually give information to the case on the case in the press in a way that would impact the trial. So often that would be like contaminating the jury pool with knowledge of the case or whatever. Which isn't to say I can't make any kind of public statements, but you got to be careful. You're limited in what you can do because the main consideration is the sanctity of the judicial process, and you're not allowed to do anything that could undermine that. So technically this is blackmail at this point. That is also a crime. I can't threaten to do something in order to coerce her into doing something she doesn't want to do. Especially if that thing that I'm threatening to do is illegal in and of itself, such as well, I mean, I guess technically publicizing information about the case wouldn't be illegal per se. It would be unethical, which are actual, as I said before, in the last video, actual rules that are enforceable, but they're not the same thing as laws, and it wouldn't be a crime for me to publicize this information. I could get in trouble with the Attorney Ethics Board and possibly have sanctions, what we call sanctions, against me, such as the lowest is just censure, which is basically where they say that was bad, don't do that. It can go all the way up to disbarment, which is permanently losing your law license. Okay, sounds like Phoenix needs to work on his poker face if he was actually pumping his fists in the air. You don't want people to be able to read you that easily. Okay, I wonder if that's the other lady that I found the photo of. Why'd I throw away the affidavit? No, I would keep that in my file. Okay, I guess I'm gonna go get the other picture and see if she has anything to say about it before I go to Blue Corp. Oh. Okay, well, I guess I won't get the other picture. I wonder if that's a saying in Japanese. The days of my youth like the scent of fresh lemon. So I'm wondering if people are being threatened. My boss was probably doing some investigation or something, some kind of lawsuit against Blue Corp would be my guess at this point. Just based on my knowledge of fiction, not any necessary. Not necessarily anything I would be coming to that conclusion in real life. Let's see what he says about... Okay. Well then. Nope, nothing else to say. I guess I will go to Blue Corp. Oh, there's the painting. Is that a fisherman? Yeah, inquirably is not a word. Also, the name that you go by, you shouldn't end a sentence with a preposition. It's that painting! So he paid off the other attorney with $5 million to make him not take the case. That's quite the thing. Indeed. I hadn't even really looked at that. Okay, let's talk to him, see what he has to say. That's not what ineffable means. I can't handle the way this guy talks. It's driving me crazy. What? What do you mean you doubt I'm capable of doing that? All I have to do is subpoena you. It's a court order. You have to appear. You don't get a choice. Because the prosecution was trying to cover up that he was in the room in the first place. That's not... I mean, he makes a good point. If the judge won't sign the subpoena or won't enforce the subpoena, then there's not really anything I can do. So if he's got the court in his pocket, I'm kind of screwed. Which I don't think I need to say that bribing a judge is a crime. It is, but like, obviously people commit crimes, so it's not outside the realm of possibility. Wait, is he punching me? Oh, yes, okay. Yeah, I'm just gonna have to suspend my disbelief about this apparent level of corruption here. There's... I'm not saying that every single person involved in the judicial system is beyond reproach, but the level of corruption that he's describing seems a little suspect to me, but it's okay, it's fiction, we can just go with it. Oh, wrong place. Oh, I wonder if I can look at the screwdriver now that he's not here to stop me. Oh, okay. Guess not. That's where I was trying to go. He's pure lovers, no. He's blackmailing you. I'm reasonably sure of that. Okay, I just said that we were going to accept the blackmail. That seems like some pretty weak blackmail, especially after all this time. I don't think it would be a big deal who, like, leaked information about a medium 15 years ago still. Alright, let's go look at the office again. This isn't the room where the murder took place. This is the lobby. I guess we'll just look at... Let's look at the most disturbing suicide we can find. That'll clearly be relevant. Okay, that's a check mark, so I guess I'm done there. Let's go talk to Mr. Grossberg again. Alright, let's see if he'll talk to me, I guess. Yeah, that's not anything. Blackmailed him. Yeah, he's right. I can't prove anything. This is, at best, wild speculation. Okay. Yeah, if he suddenly remembers that he witnessed the murder, that's gonna hurt his credibility on the stand. He could probably explain it away, say like, I didn't, I was in a hotel room with my secretary, I didn't want that to get out. That's a pretty straightforward reason for why he may have wanted to keep it on the DL. But it's not gonna help, certainly. Okay, but now you're calling into question the other witness, who says that it was Maya, so no, you need to stick with your plan, which is to frame Maya. You can, apparently with as much power as you have, you can easily punish me in some other way. You don't, this is not the right way to do this. This is going to be counterproductive. Wait. If she's out and I'm in, why is it the same view as before? Could she not tell that I was on the detention side? I guess if it's the same view on both sides, it wouldn't necessarily be obvious. Cheer me on. I don't want her defending me. Oh, I didn't think she'd take it quite that literally. More metaphorically, like, be there for moral support. Alright, we've already been over how we don't have murder trials the day after a suspect is arrested. That's not how it works. Okay, so I guess it's addressing that a little bit, but there's some constitutional concerns that would make it harder than just like instituting new timelines. Also, you don't want to put limits on the length of the case because that's mostly going to limit the prosecution's ability to present all the evidence, which if you want to convict people is not very helpful. Oh. I guess we're already to be continued, but I'm going to keep going because that was pretty short, I think. So welcome to A Real Attorney Plays Ace Attorney, Episode 2, Part 3, I suppose. Let's go. Oh hey, I've seen you in the memes also. Oh wait, you're the same dude. Okay. Shows my good memory there. That's what, like, physical and corroborating evidence is for. To, like, try and figure out who's lying and who's not. I mean, sometimes you don't have that. Sometimes it really is just one person's word against another, and you just have to try and figure out who seems more credible. Or a lot of cases get dismissed because You know, there are times where I believe that a person did a thing, but I've only got one person's word, and I don't think I can prove the case, and so it gets dismissed. Like, there's no point wasting time and resources on a trial. Trials are expensive if you can't prove the case, so... I mean, some things are worth trying just because of how important they are, but in a lot of cases, especially lower level stuff, misdemeanor thefts and things, like, you don't have enough to go on. Like, you can't prove every person did everything that they did. Most people get away with most crimes. That's just the reality of it. They never get caught in the first place. Or if they do, they end up not being convicted because you can't prove it. Okay, there's a saying. An attorney who represents himself has a fool for a client. Similar to what I said in the very first episode, you want an attorney who is not emotionally invested in the case. So, no matter how good of an attorney you are, if you're charged with a crime, you want to have an attorney represent you because you are emotionally invested in your own defense in a way that another attorney would not be. And that kind of emotional distance is helpful so you can make good decisions. Yeah, so I should not be representing myself, no matter how good I think I am. Okay, also, Maya can't be at the table with me. We have a thing called the bar. You'll hear attorney associations referred to as the Bar Association. You will hear being admitted to the practice of law as being admitted to the bar. We take the bar exam in order to become an attorney. The bar is actually a physical bar at the back of the courtroom behind the counsel tables and everything that only attorneys are allowed to pass, generally speaking. That's what being admitted to the bar means. It means you can go past the bar. Now, parties to a case, so like the attorney's clients, they can go past the bar with their attorney to sit at the table. Witnesses obviously can go past the bar to get up to the witness stand, but attorneys are the only ones who just can go past the bar. So like, if I go into court and the judge is hearing another matter before my case, I will walk past the bar and sit in front of it, whereas everybody who's not an attorney has to sit back in what's called the gallery. So in this case, because Maya is not a party to the case, because I'm the one being charged, and she's not an attorney, she could not be up at that table with me. She would have to be back in the gallery. Yeah, I should not be doing this. Okay. No. See, I am now charged with the crime. Yes, we had a trial yesterday where a lot of evidence came out. That was a different case. That would have been State of Kansas versus April May, and case number whatever. And this case would be State of Kansas versus Phoenix Wright, and case number something else. And you can't take evidence that was presented in one person's criminal trial and just say, the court is already aware of this, so I don't need to present it again. Obviously, for a game, you don't want to go over all of it because that would be boring. But in a real trial, you can't just say, oh, the court's already aware, so I'm not going to bother. Like, you have to prove every fact of your case. The court can take judicial notice of certain things, such as, like, court documents, like, this document was filed, that sort of thing. But the actual evidence in the case, you would have to represent all over again. You can't just say, oh, the court's already aware. The other exception would be like things in common knowledge. So like, one thing you always have to prove in a criminal case is that you have territorial jurisdiction, meaning that the crime occurred inside your jurisdiction. And so I will often ask, I'll ask a witness, where did this happen? And they'll give like an address, or they'll say it was by the Phillips 66 gas station. And the judge, just through his common knowledge, can know where that is and can use that to make a finding that it was inside our jurisdiction. But other than things like that aren't really specific to the case, all of the specific information about the case has to be presented, even if it's already been presented in a different trial. Okay. I get shady things are supposed to be happening. The judge wouldn't ask why he didn't testify before. As I just went over, this is a completely different court proceeding. Also, the saying the state is the master of its case. That is the legal saying that our appellate courts like to use. The state gets to decide how to present its cases, how to pursue them. The court isn't going to be second-guessing the state's decisions about the way to go about its case. Not only would they not be second-guessing it, the judge is not permitted to tell the state how to go about prosecuting its case. So, yeah, that's not even a question the judge would be asking. He may be wondering it in his own head, but he wouldn't be saying anything about it. I suppose I'll object just so I can get shut down, even though... he doesn't owe any objection, or any explanation to anyone. Yeah, exactly. Perfectly valid explanation. I didn't think we would need this person. I thought I had enough evidence without that person. I do that. I don't always call every single person who is involved in a case. Maybe I have a traffic stop, and there were 2 officers in the car, but I just need to prove that the person's taillight was out and that they didn't have insurance. I don't need to call both officers for that. I would just call the one main officer who wrote the ticket. You don't want to present cumulative evidence. So if you have enough evidence from one person, you don't necessarily need to present evidence from someone else that would back that up. Now, in a murder case, if you had 2 eyewitnesses to the murder, you would present both eyewitnesses because you want to be clear on the identity. But generally speaking, yeah, you don't necessarily always present every single piece of evidence that you have because it's overkill. It's a waste of time. Okay, that's relatable. I talked about before, you just want the witness to answer the question that was asked. If you need more information, you ask a follow-up question. Sometimes you have witnesses who are difficult because they're against you. Sometimes you just have witnesses who are difficult because, like this guy, they just want to show off how smart they are. Or they just... I don't even understand sometimes why people act the way they do, but they just won't answer a simple damn question. And it's very frustrating, especially if it's your witness who's supposed to be, like, not necessarily on your side, but, like, whose testimony is supposed to be helping your case, and they just will not answer a straightforward question with a straightforward answer. It is... I'm very much sympathizing with the prosecutor right now. And that's something that happens to everyone. That is not limited to the prosecution. That happens to defense attorneys too sometimes. People who are like, who find it exciting. Like, I would expect the bellboy to maybe be like that. Someone who finds it exciting that they're involved in this kind of a case, whereas Mr. White, he's just full of himself, and he thinks this is a waste of his time, and and he shouldn't have to be doing this. But like the bellboy, he wants to show off. He thinks it's so cool that he's part of this big important thing and he's going to be famous. Yeah, that's the kind of person I would expect to be frustrating like this. Okay, so he gave the name Red White. I don't know why he's giving his alias. I don't know why his alias... Does Nino mean red in Spanish, I guess? Blanco is white, obviously. But whatever. No. Red is Roja. Or something. I don't know. It's been a long time since I took Spanish. Okay, president and CEO are not the same thing. I'm not even a corporate lawyer and I know that. Sometimes the same person is both, but they are not the same thing. I don't really know what the difference is, but I know they are two different positions. So wait, he's denying that he knows his secretary? Did I miss that? Did I read something wrong? Okay, for some reason we don't have a jury in these cases, but this guy honestly might be bad for the prosecution just because he seems like the kind of person that would rub a jury the wrong way. Someone who is rich and full of himself. Yeah, and if the jury doesn't like your witness, that just makes them that much less likely to believe what they say. So you heard the bedlam through 2 windows and across the street. I highly doubt that. Okay, I think he said he didn't know Maya. I think impaction might be an actual word. Doesn't mean it what he thinks it means, though. Well, yeah. I saw the dude murder the girl. Yeah, if things happened that way, then the dude is guilty. Like, yes, that's true, but like that's a the word "if" is doing a lot of work in that sentence. Okay, 9 o'clock. We know that. Reading by the window. Heard a bedlam. I mean... Okay. These sometimes take me a little bit to figure out what the game wants from me. So feel free to fast forward. I'm not sure how long this is going to take. Terrible impaction. I'm not sure what the weakness is. I'm just gonna press on everything. Heard a bedlam. Yeah, I don't think you can hear. I forgot about the pressing mechanic. Oh, well that's not what I figured. Okay. I didn't have her testimony. Well, do I have her testimony? Oh, I do have her testimony. What? I'm gonna present. Yes, it does. Stupid judge. It does contradict her testimony, which is evidence. It hasn't been admitted in this case, but we apparently don't care about the rules of evidence, so... Okay. Yes. Objection. I care not. I'll answer anyway. No, once a lawyer objects, the witness is supposed to stay quiet and wait for the judge to make a ruling, and if the judge sustains the objection, the witness is not supposed to answer. But all the time, even once you tell people that, there'll be an objection, and then the witness will just start answering. So, yes. That's definitely a thing that happens, even though it's not supposed to. The judge should be stopping him, though. The very next thing after I click past it should be the judge saying, "Hold on, wait for me to rule on the objection." Okay, I think that contradicts the floor plans. Oh, wait, it contradicts this evidence. Oh, I see. This isn't the entirety of May's testimony, it's just this one fact. Alright, we've been over. We don't object when things don't line up with other evidence. That's not what an objection is. An objection is a legal criticism of whatever's happening. I'm wondering, okay, so if he really did see it to the left, that's because he was in the room and she was running to his left. They're both right. Yeah, Miss May was looking in and the victim was running to her right toward the door, and he is the killer. She was running to his left toward the door. It cracks me up how low quality the, like, attorney drawings and stuff are in that, like, wider court view. Yeah, exactly. Very good for figuring it out. Hey! They used that correctly! The judge will order people to be quiet, stop interrupting the proceedings. If you don't do what the judge says, you can be held in contempt. They actually got something right. I'm impressed. That's my job, is to propose alternative explanations and call into question your case. He's gonna say something about he was referring to someone else's left or something like that. Yes. Because she was only hit once, I think. You hit her twice. That contradicts the autopsy report. Yeah. Yes, exactly. I would object to a break. We do not want the prosecution. I couldn't say this because I can't impugn other counsel without like really good evidence to suggest it, but in my head, I don't want them to have a chance to coach their witness to fix the testimony, so I would definitely be objecting to a break. His credibility is completely shot. Although, if this is a kangaroo court, as it seems to be, it doesn't matter how bad his testimony is, the judge is still gonna convict me because he's in his pocket. So this all just doesn't really matter. Because apparently we don't have juries. Deal with it, yeah. I looked at the other window when I heard the thing fall. Okay, he said before there was only one window. Yeah, you couldn't hear that from... Why aren't we focusing on the fact that we can't hear from between two windows and across the street? Can't hear things like if it was a gunshot, then sure, but we're talking about a lamp falling over. Okay, but no, the real thing's gonna be it's out of view. He can't see that. Yeah. Oh my! That was a creepy face. Boom. Lawyered. Mr. Your Honor. Objection, Your Honor. Counsel is testifying. Counsel's coaching the witness. Yeah, it's not a bad tactic to present an alternative explanation that he would want to be covering something up, similar to how earlier I was like, he would just say he didn't come forward because he didn't want it to be known that he was in a hotel room with his secretary. So yeah, you confess to a lesser crime in order to try to get out of a more serious one. I have had defendants do that on the stand. It's a little bit of a Hail Mary tactic, but it's not a bad one as far as it goes. But that still doesn't, even if you saw the light stand then, that still doesn't mean that you'd be able to see that it got knocked over. No, because we still have the issue with him seeing her running the wrong direction. Again, that was a whole bunch of argument that would not happen during testimony. That would be during a closing argument, where you're commenting on the evidence and what conclusions the finder of fact, whether that's a judge or a jury, should make from that evidence. Would not be during the testimony. Certainly not where the witness could hear you and then change their testimony to match. Week before the murder, what information do I have? That's not true. Why he was doing it has all kinds of bearing on whether or not we believe that he was really doing it. But it doesn't prove that he did it. If they're unidentified, then they could have been literally anyone. Okay, so I've... Yeah, I was gonna say, I think I've run out. Giving up? What do you mean? I can be done cross-examining a witness without proving they're the murderer. That doesn't mean I've given up on anything. Did I just pass out? Oh, yeah, I think I did. Did I? Okay, I did pass out again. Is that their mom? Oh, okay. Wait. Since when did she... Oh, is she channeling Mia? Okay, and then Mia immediately undid the front of Maya's shirt because, of course, she did her kimono, whatever that is. Oh, perfect. He said that it happened the week before. September 4th is still the beginning of September, I don't think. If all the rest of that wasn't enough to call into question his testimony, I don't think, like, it wasn't the beginning of September, it was September 4th. It wasn't the week before, it was the day before. Well, I don't think that would do a whole lot. He's gloating, that's going to be his downfall. Although actually, so the way a trial is set up, the state goes first and they present what's called their case in chief, which is all their evidence that they have, or all the evidence they think they need to present. Then the defendant has the opportunity to present their case in chief. So this witness was called by the prosecution, meaning it's part of the prosecution's case. After the prosecution rested, meaning I'm done presenting evidence, then the defendant would have a chance to go. Normally the defendant doesn't present much unless they have like an alibi or something they want to present, or the defendant's own testimony is the most common thing. But the defendant can recall any of the prosecution's witnesses that they want to if there's more they want to get out. So I absolutely would have the ability to recall this witness and ask him more questions. Oh wait, I'm not paying enough attention, I have to go back. Okay. Present the receipt. So this is not in evidence. We've talked about the rules of evidence. I would have to probably call Detective Gumshoe and be like, we found this receipt at the scene before I could do this with it, but we're gonna skip that part apparently. Because right now, it's like, this is a piece of paper, it's not been authenticated, it could be anything, we don't know what it was. We need someone, like the detective, to authenticate where it is and where it came from, or what it is and where it came from. It's so convenient that all these things... I can't remember what the details were, but in the previous trial there was something like that too, where it was like something, they said they'd seen something at a certain point in time, but it wasn't there until a later point in time. Hopefully not all of the trials in this game turn on something like that. That guy needs to calm down. What rabbit is he gonna pull out of his hat? Again, I don't have to prove myself innocent. You have to prove me guilty. You have to prove it beyond a reasonable doubt. Even if I haven't proved my innocence, I have definitely created reasonable doubt. His guilt isn't necessarily obvious, but the fact that he's lying is completely obvious. So, and he's all the evidence the state has is his eyewitness testimony. Okay, she can't be up at the table with me. She definitely can't be speaking out of turn. She has nothing to this case. Yeah, she can't be doing this. She could have whispered something to me potentially if she was allowed to be at the table with me. But she couldn't be speaking directly to the court. Again, just like everything, I would have to be authenticating this somehow to prove that it is something written by Mia in her own handwriting. Okay, again, blackmail. If he admits it to prevent this from being like released, that doesn't necessarily prove that he's guilty of murdering her. It just proves he doesn't want this released and he's willing to say anything to stop it. That could be for all kinds of reasons. I mean, that's the correct outcome. This witness's testimony was completely unreliable. Even if in this kind of a case, even if the jury, okay, again, no jury. There should be a jury. Even if the jury had convicted me, the judge should enter what's called a judgment notwithstanding the verdict, which is basically where you say, I don't care that the jury found you guilty. I'm saying you are not guilty. I'm finding you not guilty, which is a power the judge has if the jury makes a wrong decision. They can't do it the other way around. So if the jury says not guilty, the judge can't be like, no, you're wrong, they are guilty. If the jury says not guilty, that's final. But the judge also can say not guilty, overriding the jury, and that's just an extra protection for defendants to prevent cases where maybe public passions have been inflamed by whatever, but basically to prevent cases where a jury is convicting someone wrongfully. Oh, that's another thing they do right. Not guilty. They're not finding me innocent. They're finding me not guilty. And that's because, as I talked about, the prosecution has to prove that I am guilty. And so if they fail to prove their case, then I am not guilty. That doesn't mean that I'm innocent. It just means that the prosecution did not prove that I am guilty. Uh, so, like, you can have someone who did the thing not get convicted. That doesn't mean they didn't do the thing. It just means that they were not found guilty. Your time would be running out anyway. Even if her powers weren't weak, you shouldn't just, like, hijack your sister's body forever. Like, you're here to visit, and then she gets to go on living her life. Sorry, I stopped because this music sounds extremely familiar to me, and I'm trying to figure out if it's from this game only or if it's from something else. And I don't know, so I'm just gonna keep going. Nick is a terrible nickname. Well, that's creepy. The end. All's well that ends well. Well, I hope you guys are still having fun with this. Just unlocked episode 3. It seems like the amount of content I'm able to get out of this, I don't like that word. It seems like the amount of new legal issues that are arising is kind of declining, which doesn't surprise me. I would expect things to, the problems from one case to another to be similar. So we'll see. I might try and do this again, or we might say this was the end of the little mini-series. But either way, thanks for watching. I will put a link on the screen to the playlist of all the other episodes, and subscribe so that you can get a notification if and when I do episode 3. But that's all for me this time. Thanks. Bye.